Hello, America. Welcome back to the second part of Beat Gun Charge in Massachusetts, presented to the American people on or about May 6, 2022. In part 1, we said that there is no license to bear arms. And in this part, we're going to discuss how there is no court of competent jurisdiction. So from part 1, we learned that the license to carry is a contract, and it's a professional license, that is, to carry for hire. The unlicensed possession of a firearm itself is a regulatory crime, and that regulations are created and enforced by the executive branch agencies through adjudicatory proceedings or administrative actions. So in part 1, I showed you this chart, and it describes various professions with their licensed entitlement and the executive branch agencies to which they are accountable. For example, doctors are accountable to the medical board. Child care providers are accountable to the Department of Early Education and Care. Dentists and dental hygienists are accountable to the dental board, and so forth. And public safety and security officers or other persons who carry firearms are accountable to the Executive Office of Public Safety and Security. When a doctor gets in trouble for not having a license, he goes before the medical board. When a dentist gets in trouble for malpractice, he goes before the dental board, and so forth. So an allegation of unlicensed conduct for carrying firearms would go before the Executive Office of Public Safety and Security. Which of these are courts? None of them, because it is said that regulations are written and enforced by executive branch agencies. So therefore, you're not even in a court. And if it were a court, the indispensable party would be the Executive Office of Public Safety and Security. Just like if your medical license was in jeopardy, it would be the medical board, which would be the indispensable party. Or, in the case of carrying firearms, the Department of Criminal Justice and Information Services, which is subordinate to the Executive Office of Public Safety and Security, or the Firearms Licensing Review Board. None of these are joined as parties. Therefore, there's a failure to join indispensable party, and the action should be dismissed. Now, if the executive branch agency has neither appeared to enforce nor to adjudicate an alleged licensing violation, then who is administering the enforcement action? Can it be the court? Well, let's take a look at the Massachusetts Constitution. It says the judicial shall never exercise the executive or the legislative powers, or either of them. To the end, it may be a government of laws and not of men. Can it be the judge? Well, according to the Massachusetts Constitution, it is the right of every citizen to be tried by judges as free, impartial, and independent as the lot of humanity will admit. So let me ask you this. Can a judge be a judicial officer if assigned the duties of an executive branch agency? Of course not. He's an executive officer in an adjudicatory proceeding or an administrative action. Can a judge be free, impartial, and independent while performing the functions of an executive branch agency when the prosecutor is also a member of the executive branch of government? Obviously not. So therefore the judge can't be a judge. The license to carry is a contract with the government for a professional entitlement to carry for hire. Since there is no duty to consent to contract with the government for a professional entitlement in order to exercise a constitutional right, there is no consent and therefore no contract. If you were exercising the right to keep and bear and not the licensed entitlement to possess or carry, and you had arms for personal use and not firearms defined in reference to a commercial activity, then the court has no subject matter jurisdiction. If the court is not a court, and the indispensable party is absent, and the judge can't be a judge, and there's no valid contract or consent, and there's no competent subject matter jurisdiction, then what kind of court are you in? Let us read. The history of the present king is a history of repeated injuries and usurpations. He has refused the establishment of judiciary powers. He has taken away our charters, abolishing our most valuable laws and altering, fundamentally, the forms of our government, to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, giving his assent to acts of pretended legislation, transporting us beyond seas to be tried for pretended offenses. See the Declaration of Independence. We have no court, we have no judge, we have no contract, we have no consent, and we have no indispensable party, and there is no competent subject matter jurisdiction. These are all examples of a jurisdictional challenge. In blue, you will see mostly your due process rights, and on the left, you'll see the subject matter jurisdiction of the court, also known as the essential elements. Each of these are subject to a jurisdictional challenge. For example, it is constitutionally impermissible to presume that a license is required for the right to keep and bear arms. It is constitutionally impermissible to presume that the subject is carrying or possessing a firearm when in fact he or she may be keeping and bearing arms. And it's also constitutionally impermissible to presume that the person keeping and bearing arms can have knowledge of what the word carry or possess means, because neither of those terms are explicitly defined by the statute. And so it is that there are a number of jurisdictional challenges available, at least 22, but if you hire an attorney, here's your conventional defense. It's going to rely on the suppression of statements under the Fifth Amendment, the suppression of evidence under the Fourth Amendment, and that's pretty much all you get. It's often said that he who defends himself has a fool for a client. Well, I say he who does not defend himself is a fool, because if you or your attorney fails to invoke the terms of the Constitution, then you shall forfeit the protection of the supreme law of the land and be transported beyond seas to be tried for pretended offenses by acts of pretended legislation, subject to a jurisdiction foreign to our Constitution and unacknowledged by our laws. Just remember, no man in the United States has ever been charged, tried, convicted, or sentenced for keeping and bearing arms. Therefore, keep and bear arms. Arms for personal use under Mass General Laws Chapter 62C. Arms in defense of property under Mass General Laws 149. Arms to aid officers in Mass General Laws 269. Arms such as military arms, uniform, and equipment, Mass General Law Chapter 60. Arms for the common defense under the Massachusetts Constitution, and arms necessary to the security of a free state under the United States Constitution. Carry nothing and possess no firearms unless you're licensed to perform a duty for hire. Bear arms because law secures liberty without license. Thank you for watching.